And again, this is Judge Alyssa Perez resuming the civil docket for the 210th District Court for April 27th, 2022. All matters being heard are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition, we're streaming all matters live via YouTube. Mr. Madoff, would you call our next case, please?
In cause number 2011-2614, Cascos Investments Inc. versus Robert G. Hu. Announcement of council, please.
Robert Hedeke on behalf of Robert Poole, Your Honor.
Good morning.
Sorry, Judge Michael Hirsch on behalf of Casco.
Okay. Let me go ahead. I need to stop my video really quickly, but we can keep going. We're scheduled for a status conference. I believe Mr. Hirsch, you all recently subbed in. Someone give me an update because I know we don't have, we've had some delays. We had a recent motion for continuance. Someone give me an update on this, please.
Judge, we were pretty much just looking for a trial date.
Okay. How soon are you all? I'm thinking just in terms of the court's calendar, we're probably looking somewhere in September. Do you need any hearings leading up to that?
Your Honor, I anticipate probably filing of a motion for partial summary judgment,
Okay.
which will address one of the preliminary issues in the case, which has to do with the transfer of the real estate.
Sure.
And then I'm, as my motion for continuance indicated, I'm undergoing some health issues that really limit my mobility. And frankly, I would look at the first of the year as being probably a better time for scheduling the case to let us get some preliminary matters disposed of.
Okay. Mr. Hirsch, are you, I mean, this case has been pending a long time. It doesn't give the court any kind of heartburn to put it at the beginning of 2023. I would like to have a scheduling order in place just for deadlines for any things that might come up as we restart it. So I'm going to look at early February, Myrna, 2023, whatever our next, but actually on this one, we probably need to specially set it because it has been, if we get there, it has been pending for so long that so look for a good date, Myrna, in February where we can specially set this case. And so we'll get you all a scheduling order with the appropriate date. And if you all will complete it and return it, we'll get on track. Okay. Mr. Hedeke, in the meantime, whatever you do file, same for you, Mr. Hirsch, anything you all need a hearing on, just email your filed stamped copy of your pleading to Ms. Hernandez, and we'll get your hearing scheduled, okay?
Thank you very much, Your Honor. Greatly appreciated.
No worries. Take care. Thank you, Mr. Hirsch.
Thank you. May we be excused?
Yes, thank you. All right. So I think that leaves us with Ms. Labinati and Mr. Jessup. So let's go ahead and get started on that one.
In cause number 2020, DCV 2000, Arthur Benegowski versus State Farm Mutual Automobile Insurance Company and Thomas Craig Matthews. Announcement of council, please.
Good morning, Your Honor. Again, Daniela Labinati for the plaintiff.
Cliff Jessup for defendant State Farm, Judge.
Okay, good morning. And I'll just tell you right off the bat, I have reviewed, I think everything up and through yesterday. Unfortunately, I had to change of plans and had to operate remotely this morning. So everything I printed and all my notes stayed at the office. So I'll be operating off of memory, but I did review the various supplements and the different things that you all had emailed to the court. So thank you for that. All right. I don't know. I'm going to ask Mr. Jessup to go ahead and start.
Yes, Judge. So there's two issues right now, or they're related issues. One of them, obviously, Your Honor, is the notice of intent to use previous criminal convictions under Rule 609. It's been objected to. There was a hearing on this last October. You may recall our motion has a transcript of the hearing we had. At that hearing, we discussed that some of the issues needed to be fleshed out in terms of confinement, in terms of release during the deposition. At the recent deposition of Mr. Biganowski, we began to ask him questions about that. We also began to ask him questions about his previous conviction, at which point Ms. Lebanati instructed him not to answer and put a stop to the deposition, preventing us from continuing to flesh out the record with regards to his criminal conviction, his release from confinement. One of the issues, and it's pointed out in our motion, is that he testified in his deposition that as of 2010, he was released from confinement and he was done with parole. That seems to contradict the federal records we have, and we've attached them to our motion, which shows he was still getting a modification to his parole as of at least May 25th, 2012. We intended to ask, or I began to ask him questions with regards to his conviction. I started asking about co-conspirators to determine what the sentences were for everybody and to get into all of those issues when the deposition was stopped. So we're here on two motions, Judge. Number one, obviously, is as the court has heard and has been briefed, is the previous convictions we believe are relevant in this case, given specifically the dispute with regards to how the accident occurred, and it's a credibility issue there, but then more particularly with regards to his Mayo Clinic records. And I do believe I read Ms. Lebanati's response where I was called slanderous for referencing records that don't exist. And I'd be happy to share my screen with the court and show the issue we anticipate and the reason why we believe this might be an issue going forward. If that's okay with the court, I'll share my screen.
Sure. I'm not in charge of the settings. So Mr. Marufo or whoever are you getting something that tells you you're not able to?
Attempting
There
to
you
now.
go. Yes.
And if you can see, these are records from the Mayo Clinic produced by plaintiff. And so if you look, can you see it, Judge?
I'm trying to see if I can zoom it.
I can zoom it, Judge.
I did it.
Okay, so this is page 308 of a 326-page record produced to us by plaintiff from the Mayo Clinic. And just as a bit of background, Your Honor, plaintiff received a laminectomy L3, L4 at the Mayo Clinic from a surgeon named Patel on May 14th, 2019. So here, Judge, this is a pre-surgical consultation from December 18th, 2018 at the Mayo Clinic. And these are Mr. Patel's notes of his discussion with Mr. Biganowski. He says, Arthur Biganowski is a 75-year-old physician with a history of low back pain as well as prostate cancer. Patient has a long history of low back pain with intermittent bilateral lower extremity radiation. The patient has undergone physical therapy as well as trials with medications for this. He has had epidural steroid injections as well. Although his back pain appears to be manageable, his real issue is that of impending bowel and bladder incontinence. The patient states that although he has not had any incontinence episodes, that he has.
Excuse me, sir. Could you read a little slower, please?
Sorry?
Read a little slower, please.
Oh, I'm sorry. Sure. The patient states that although he has not had any incontinence episodes, that he has to quickly get to the bathroom in order to avoid an accident. The urgency has progressed. Patient underwent an MRI. August 2018 confirmed the presence of severe spinal stenosis at L3-L4. As I had performed a laminectomy on his friend in El Paso, Texas, he wished for my opinion here at the Mayo Clinic regarding the surgery for spinal stenosis. And the reason why this is important, Judge, is because, like I said, he subsequently did receive the laminectomy, and then he had a follow-up with Dr. Patel on October 30th, 2019, so more than 6 months after the accident, or after the surgery. And on October 30th, 2019, they review his progress after the laminectomy. They reviewed his strength, his function, and then there's a note in here from Dr. Patel that says, of note is that there is the fact that there was an inaccuracy in the medical record that the patient detected. In my original note dated December 18th, I stated that he had a long history of low back pain. The patient has corrected me on this. The patient did not have back pain until recently when he began to experience low back pain after a motor vehicle accident in 2018. After the accident, the patient was evaluated by a neurosurgeon in El Paso and an orthopedic surgeon in El Paso and found to have spinal stenosis. He was found to have tears of the gluteus musculature. Ultimately, despite non-operative therapies, he was unable to improve. And when he developed bowel and bladder function, This prompted surgical opinion and eventual surgery. And so, Your Honor, the issue becomes really important here, Your Honor, because as we briefed in our report and as we would like to develop in his deposition testimony, the reason why he was convicted, I'm sorry, let me stop sharing my screen, Judge. The reason why he was convicted, or he was ultimately convicted for mail fraud, but the allegation in the charges was that he would create, exaggerate, or change medical records in order to defraud. The eventual conviction was for Medicare, but it was for insurance companies such as my client, State Farm, Judge. And so we do think it is.
Mr. Jessup, I see what you're saying here, but okay, so the records that you provided show, for example, on one date, the doctor is putting in terms of Mr. Biganowski's medical history, initially was the long-term issues, right?
Correct.
And then on this last record, the doctor is going in there and saying, I made a mistake because the patient has corrected me. He did not have these long-term issues. He only started having these issues since the accident, right?
Correct, Judge.
So how is it that we need to have the conviction, everything regarding his previous federal case? Doesn't that in of itself, the jury can take it for what it is? We don't need to know about the entire conviction and I guess the nature of his conviction. I mean, I just don't know why we have to go that far. The records kind of speak for themselves, don't they? I mean, whether he was convicted of that crime, which he was, how does that impact a jury's reading of what the doctor has entered in there?
Well, there's a couple of issues on that point, Judge. Number one, obviously, it's not anyone's intention or not our intention to go in and tell the jury that. We would like to develop this testimony through deposition so that in the event the door is opened, in the event the jury is misled, it would be used for impeachment, Judge. I don't anticipate going in with the convictions starting off, Judge. I don't think tactically that'd be a very, very effective procedure in this case. But we would like to develop that testimony through deposition so that we're completely clear in terms of all of that. The other issue, Judge, also is during his deposition, he corrected me and he calls himself Dr. Biganowski. I'd like to ask him the circumstances when he lost his license, because especially when you have a doctor testifying about injuries, I do think a jury is going to give him more weight in that regards. And so that's another aspect of his deposition testimony we need to develop. And again, Your Honor, this notice was filed for impeachment purposes. It's nobody's intention to go out and to start this trial by calling him a convicted felon. But if the door's open and if the jury is misled, Your Honor, I do think they have a right to hear the truth if they are misled. And we need to develop that testimony and that evidence through the depositions, Judge.
Okay. Tell me, Mr. Jessup, I mean, I don't want there to be, just because we went kind of the deposition route before, and it seems that I don't know that it accomplished, maybe, I don't know if I had any thoughts on what it was going to accomplish, but it didn't get us to a point where there was some agreement. I want to know what it is specifically you want to ask and proceed on if there's a continuation of that deposition.
Sure, Judge. I would just like to know the circumstances of his conviction, the allegations, the circumstances of his conviction, his sentence. There were co-conspirators. I want to know about their sentence, if anyone's still in prison or not. And then obviously his release. There is some question with regards to the nature of his release, whether he was on parole or probation, the nature of his release, and when he was released from confinement, obviously with regards to the dates. That was about as far as I intended to go on the criminal conviction side on his deposition. Like I also said before, I wanted to talk about his medical license as well, and the circumstances surrounding the suspension of his medical license, Judge. And apart from that, obviously the intention after that, Judge, was to get into in his deposition his any previous injuries, previous accidents, and then we would go through this accident, and then obviously his course of treatment, Judge. And I think that's about as far as I intended to go in the deposition.
Anything else, Mr. Jessup?
Nothing else at this time, Judge. I do think that instruction from the court would definitely help us to get this issue resolved so that we can move on and, get the rest of this case, get the rest of the deposition testimony developed without any further dispute, and a ruling on the court will help us to, again, be able to get this case presented as quickly as we can, Judge.
All right. Ms. Labinati, can we start with the issues that Mr. Jessup has identified in terms of restarting the deposition? Let me hear your position on that.
With regard to restarting the deposition, okay, so aside from the other issues, Judge, that you hit the nail on the head, it's in the medical record. We have many car crashes where plaintiffs say one thing to the doctor, some of the things are not there. So there's things that they tell the doctors that it's not there. And that's always the battle that every plaintiff's attorney faces, because there's somebody else who writes the record. There is an assistant who writes the record. So these things go on every day. We try cases every day. And this has never happened before, where any attorney is trying to bring a 22-year conviction, or on a plaintiff side, for me to bring a 22-year conviction of the defendant in this case. Everything is about credibility, but the law is very clear that a conviction over 10 years old, doesn't go in for purpose of impeachment. All the cases that we have cited, Judge, including criminal cases, the courts have even allowed it only if it involves a subsequent conviction that is similar. So on the Theos factors, if there is a subsequent conviction that is similar, the courts have said that sometimes the court may consider that, and only if the defendant meets the burden, and they have the burden, that the probative value of having that similar conviction outweighs the prejudicial effect. Mr. Beganowski does not have a subsequent conviction under the Theos factors. There has never been a subsequent conviction. This happened more than 22 years ago. He did not prepare the Mayo Clinic record. So the record, like you said, Your Honor, I mean, you had it right. That question was right on point, was prepared by the Mayo Clinic based on the patient history. And that information is recorded there both ways, right? That the doctor says, oh, I made a mistake, I thought this. He can impeach Mr. Beganowski on that. But bring in this conviction, Judge, I mean, you know what's going to happen. There's no way of winning this. There's no jury that can pass over that. That is exactly why they want to bring it. And that is why we have that law to begin with. That's why the law says no. The prejudicial effect of that will outweigh any probative value on a motor vehicle accident case. There's not even a connection. He doesn't work for the Mayo Clinic. He doesn't have anything that his office could have tempered it. Remember what happened in 1998. Mr. Beganowski had that office. It was his business, his office. So there was an issue with the billing practices, the billing that they submitted to Medicare, as many other entities here in El Paso County, Texas. I'm sure the court is familiar with Columbia. So in it, what happened with it, former HCA hospital. But anyway, Mayo Clinic is not something that Mr. Beganowski has any partnership, relationship. He is like any other plaintiff that we deal on every case where they say, we told the doctor about my shoulder, he didn't put it in there, I told him later. That's something that we see on every motor vehicle accident. We see it with every record. So this is not unusual. You know very well, Judge, why they want to bring this. And there is two factors they have to meet. They have to meet the 10-year test, which they haven't met. They brought in the Theos opinion that the court looked at a subsequent similar conviction, which they haven't met. And even in that, they said, even if they have that, the defendant still has to meet the burden that the prejudicial effect is not outweighed. In this case, Judge, there's no connection. If it was a similar situation that Mr. Beganowski has now his own practice, and we're dealing with a similar issue, then I can see their argument. There's no connection, Judge. The court last hearing said, this is my question, and he attached the record, so I'm going to read what the court said. Has anyone briefed, I guess in this context, what release from confinement means? So that's really what the judge was looking at. What is the definition of release from confinement? Confinement could be limited to actually being confined in some kind of detention facility. But is there anything that guides us with respect to confinement and how it relates to community service? So I understood the court's question and I agreed with the court's question. And that's why I said, hey, let's clarify, because I didn't want to make a misrepresentation that he was released in a different date, that my understanding. So I said, hey, I agree, he's entitled to that information. But he did, Judge. He did testify as to the release date, as to the confinement date. He did testify as to what the charges were. I stopped my client when he came to the point, like, tell me about your co-conspirators. What does that have to do with anything? What is that? They're not a part in this case. What is the co-conspirators have anything to do with that? He wants to talk about the circumstances. You can print it out, Judge. It's on Google. Put up, I did the same thing. I printed it out. If he wants to know the trial or the opinion of the court, he can print it out. The circumstances, I mean, my client pled non-guilty. He was found guilty. All I have to do is ask him to plead the fifth on that, but we're not going to retry that case again. I have never, Judge, had this thing happen. Even when I've had felons client, which I've had less than 10 years, the question is, what were you convicted of? I was convicted of a robbery. I was convicted of this. There was never a question, how did you commit the robbery? Really? Who was your co-conspirator? I've never heard of such a thing, Judge. Why is this happening to Mr. Wiganowski? As far as his MD license, well, Judge, a doctor is a doctor. If I lose my license as an attorney, I'm still JD. Like I tell my son, nobody can take away your education from you. Mr. Wiganowski finished his medical school. He is a MD because he completed his medical school and he calls himself a doctor. Like somebody who has a PhD calls themselves a doctor, that somebody who has a law degree, sometimes they call themselves a doctor. That doesn't mean that he's a practicing licensing doctor. He did tell Mr. Jessup, I have not been a doctor since 1988. He told him the day that his license was suspended and he has no longer practiced medicine. He provided that day. But to go into these details, Judge, is just absolutely for harassment. There's no reason behind it. We are 22 years later in a car crash. Like you said, Judge, if you want to impeach him on the records, you have the records yourself. You can say, well, initially you told the doctor this, and now it's this, right? Like on every other case. This is turned into, and I believe my client feels, and I don't know, Judge, because I'm not that old to have lived long enough to know what happened in El Paso during that time. But I just feel like my client feels like this is just absolutely harassment, very personal. I'll know that during that time he was working with a lot of these firms or against these firms. So this thing just keeps on getting deeper, and I'm going to have to go into more things that I don't want to do. I respect the firm. I want to continue us to have a relationship. This is just going to a place that doesn't need to be. We have a car crash. We don't have a fraud case for medical records. My client did not prepare those medical records. My client is not the author of those medical records. My client did not conduct the surgery. My client did not do the surgery. So this is, and I've never seen this, Judge. I'm being honest with you, Judge. I've had a case where 7 felony convictions. And the only question allowed was, are you a convicted felon? The defense attorney could not even ask how many. Only are you felon convicted. This has gone too far.
Let me go ahead and just stop you right there because I have one additional question for you. Ms. Labinati, if I recall from the previous hearing, you had mentioned something about a protective order. Are you still requesting that? And what is the scope of that request?
I am asking a protective order, Your Honor, to where he's not allowed to talk about the trial and the circumstances of those events. The only answer should be the date of the conviction, the date of the release, what was he convicted of, and what was he charged of? Nothing else. He can ask about when was his medical license suspended. I have no problem with that. And if he was on home, there was, I believe, 1 year, and he already testified 1 year that he stayed at home arrest. He can testify to that, but he already testified to that, Judge. But anything else about, well, what happened? What did you do? how did this thing happen? Who are your co-conspirators? How did you submit the billing to Medicare? That was already tried with his attorneys in 1998. We're not retrying that case. And at that point, Judge, most of it, I don't even know what's happening. I wasn't even his attorney. So I have to instruct him to plead the fifth. Mr. Jessup has put me in a very bad position here.
So, okay. And I think, actually, I wanted to give you each a moment to go through some things. And I think, Mr. Jessup, you identified for me what has continued to be kind of the crux issue here. And I appreciate both of you all putting all the effort, because I think they are important issues. And I see each of your all's position. However, Mr. Jessup, I continue to remain stuck on the one question. And actually, I think there were two standards in there, with respect to whether, on the issue of the conviction, right? And the sentence. And I think, I guess that is important in a certain sense, because at least as to that factor regarding the probative value of the evidence, one is substantially outweighs versus outweighs. In either case, if the sentence is either upwards or lower of 10 years, I still do not see that the probative value of all of the issues and everything that has to do with that criminal case either substantially or just outweighs the prejudicial value. I don't see, even with the topics that you've outlined, in other words, in proceeding with the deposition, the co-defendant sentence, the circumstances of the conviction, all of those things, to me, still do not outweigh or substantially outweigh the prejudicial effect I think it will have with respect to this case. And so I'm not sure to what extent Mr. Biganowski is going around or refers to himself as doctor. Obviously, the questions regarding his license suspension, it sounds like I'm hearing they've been asked, prior injury and obviously treatment, all of that I think is fair game. But with respect to the use of the previous conviction, I'm going to deny that request. Again, I think, I don't know if I was totally clear or was decided with respect in terms of the timing of the conviction, but in either event, I don't think it comes in. So, Ms. Labinati, I don't know what, if you want to memorialize what your request is for the protective order, if that helps in terms of moving things along. I will review it. I don't know that I agree with everything that you mentioned, but I don't know that I've seen a proposed protective order.
I understand.
I'll look at it.
I will draft one. I will send it to Mr. Jessup to see if we can reach an agreement. And if not, then I'll just send it to the court. I understand what the court is ruling on the issue. And I don't have a problem having Mr. Biganowski appearing for the rest of the deposition, Judge. I understand Mr. Jessup has not been able to ask question about the accident. So I don't have a problem with that. But maybe after today's hearing and the court's guidance, maybe Mr. Jessup and I can discuss and reach an agreement, and we'll take it from them.
One of the other issues, what is our next setting?
We are set for trial, Your Honor, and I understand that Mr. Jessup has not completed his deposition. He did.
So our actual next setting is what, our docket call?
I believe so, Judge.
It is? Okay, so that's not going to work. I mean, I think, yeah, that's definitely not going to work. I don't know if there's going to be any residual matters from today, but we need to go ahead and convert that docket call to a status conference, or just add a status conference. I'll just say this: anything in the interim that you all need to file and want heard, please forward that to us. Also, once you all talk, we need to get a new trial track squared away. That's where I'm coming from. I know you probably will be discussing an even bigger picture than that, but I just know that we're going to need to get some dates squared away. So if you have proposed orders, Ms. Labonati, please send them.
Yes.
Anticipate with respect to the protective order. Mr. Jessup, I know you will have some input. And so if we need to have a hearing, happy to do that. We can even do it on the docket call date if it's not too far out. I'm just not looking at Odyssey because if I do that on my home computer, it'll crash my.
There is a June 8th judge date. I don't know that date is, it says final civil pretrial conference. So actually
well,
that is before the
That's the
doc.
next date. Okay, so anticipate we can have anything heard on that date unless you need it sooner, okay?
Okay,
Just let us know
Yes,
what you
Judge.
have. Okay,
thank
all
you,
right.
Your Honor.
thank you very much. Y'all
Thank
are,
you, Judge.
Judge, bye-bye.
bye-bye.